For this week's Toil and Trouble slot, I'm talking to Tompkins Wake partner Daniel Erickson about an ERA decision from Christchurch that established a personal grievance claim could be heard even when it was far outside the 90-day timeframe people usually have because of exceptional circumstances. Thank you very much for coming in.
Not a problem.
Now let's just summarise this case if we can.
Yeah, well, Mr. Asieto was the employee for a company in Queenstown, and there was a falling out with his employer. And he felt as though he'd been constructively resigned, which is essentially a forced resignation. He went and consulted an employment advocate for advice on the situation, but the advocate, for reasons that were explored in the determination, didn't raise the personal grievance within the 90-day time frame. And in fact, it wasn't until quite a number of months later when the employee reached out again to the advocate, essentially to say what's happening with my case, that it came to light that nothing had happened. So if an employee in situations such as this wants to pursue a personal grievance, there's only two ways they can do so. The first is if the employer consents to the grievance being raised late, or secondly, if they establish some kind of exceptional circumstances. And that's what happened in this case.
Right.
One of the exceptional circumstances referred to in the Employment Relations Act is where the employee takes steps to instruct an agent or a representative to raise the grievance on their behalf, and for some reason it doesn't happen. And that's what happened in this case.
So there's a couple of things here, obviously, but I mean, one thing that must happen quite a bit is this happens on construction sites where people's English is not their first language.
That's right. Yep.
And there was also an element of culture in the way that this man pursued it.
So Mr. Asieto is a Filipino man, and he spoke in his evidence before the authority about in his culture, you would have respect for someone in the situation of a lawyer and trust that they were looking after you. Now, in this case, the person he instructed wasn't a lawyer. They were an employment advocate, but he seems to have thought the person was a lawyer. And so he, I guess, out of that respect, didn't follow up within, it was a number of months later that he eventually did.
Absolutely shocking. The judge actually warned the advocate that he was on thin ice because he'd done this a few times before.
Yeah, that's right. And the advocate wasn't named, which is probably sensible because, I mean, there were some relatively adverse statements made about them. But the authority member more or less put the advocate on notice that if this happens again, I will name you.
Yeah.
And the advocate explained that there were some health issues that were part of the delay.
His health issues?
His health issues, the advocate's health issues. Okay. But the authority member reading the determination wasn't necessarily impressed by that explanation because he noted there was actually no medical evidence. But ultimately what it came down to was the sense, I guess, from the authority member, it would be unjust if the employee wasn't able to pursue his case because it was not his fault. He had taken steps to have it raised. Now, I guess there is that question mark over could the employee have done more over the course of those few months to follow up, to chase up and get the matter progressed. But the authority member did accept his evidence about that cultural aspect.
If you are, say, a born New Zealander, English is your first language, you might not have that excuse. But what are some of the other reasons you might have for doing this so far out of the time frame?
Well, one of the other ones which is quite common is that if you have been affected by the grievance to such an extent that you can't reasonably take steps to raise the grievance, and that will often be if it's a stress-related case, bullying, harassment, something like that, where the employee has, for example, suffered mental illness as a result of the way they've been treated, so they haven't been able to properly turn their mind to raising a personal grievance. But bearing in mind that the time frame is relatively short, it's 90 days, although that just recently it's been extended to 12 months for sexual harassment grievances. And the authority does note that in the determination that it is a relatively short time frame. So that's the other one we see quite a lot, is where the employee claims they've been so affected they can't potentially raised a grievance. But I think you're quite right about the cultural aspect as well. You know, if someone was English was their first language, then perhaps they wouldn't have, if there wasn't that cultural aspect, they wouldn't get as much leeway as perhaps the person has in this case.
How do you rate the way the employer acted in this case, from what you read?
Yeah, it's difficult to say. I think that they did validly question the length of time. I feel like that would be a question worth asking, is, yes, I understand that your advocate has let you down, but it has been quite a few months since then. Whereas if it was, you're talking a case of a few days, a couple of weeks, then as an employer you might just give your consent because there appears on the face of it to be a reasonable explanation and it's not the employee's fault. So I don't think we can be too critical of the employer for questioning it in this case, especially given that length of time.
Though the employer had issues with this man's employment.
That's right.
And that's what kicked it all off.
Yeah.
Though the judge said the man didn't really have a strong case for a personal grievance.
Well, that's right. And it is difficult to say at that early stage because the authority wouldn't yet have had the full evidence that, when it does come to, if it does come back before the authority substantively, there will be more detailed evidence given. So it is hard at an early stage to look at a case and say whether or not the person will ultimately succeed. But I get the authority can look at the merits of the case, and when it's deciding whether or not to grant leave or decide there was an exceptional circumstance, it is required to look whether it's overall in the interest of justice to do so. So it can look at the relative strengths of the case, but bearing in mind it's at an early stage, so it's not necessarily a very high threshold.
Just finally, the government is obviously moving to sort of tighten up personal grievances a little bit.
Sure.
Do you think that will affect exceptional circumstances, or will the judge sort of read that as a change to it?
I'd be surprised if this particular aspect of the Employment Relations Act was changed, given that, as I said before, the timeframe is relatively short anyway for 90 days. Now, if there was going to be tightening up on personal grievances, personally, I wouldn't be surprised if it was something like they have in Australia where there's an income threshold, and if you earn over a certain level, you cannot pursue a personal grievance. So that's one change that I would say is more likely than tinkering around with the exceptional circumstances.
NBR is offering a special July-only deal, $399 for a year's subscription, so you'll be able to find me on nbr.co.nz.